welcome to another exciting episode of Unraveling Intellectual Property with Michael Stein. I have here Sahil Chiniwala, one of my 2026 interns, and today we're going to be talking about protecting AI or preventing AI exploitation and deepfakes, particularly amongst celebrities, but it could apply to anybody. Welcome, Sahil. It's been a pleasure having you this term, and you've done a great job for us.
Thank you. I've learned a lot. It's been an amazing learning experience.
Well, I'm glad. I try, and I know you tried extremely hard. Let's get into the topic. So we're talking about,
Yeah,
AI is becoming big. People are using it for all kinds of purposes, using people's likenesses, blah, blah, blah. And I know you've done a
yes.
little research.
Yeah, so one example of AI has one of the ways that AI has been being used has been in deepfakes, specifically of celebrities. And for example, one way that some celebrities are using or have used recently to combat that has been something that Matthew McConaughey first did when he trademarked his statement, "All right, all right, all right." And his goal in trademarking that statement was to combat deepfake AI and sort of stop it from using the statement. But trademarks are specifically usually used in relation to goods and services. So do you think a trademark is effective against deepfake AI?
Well, actually, he filed and received 8 trademark registrations, not just the one. There's one where I believe he's sitting in front of a fireplace for 3 seconds, and then there's a 7-second one for where he's uh, outside on his porch. And then there's one with his something about just say living. Oh, just keep living, right? Which is the name of his company. So he's been the first, although he's started, I don't know, it's going to be a stampede, but Taylor Swift, I know, has done some stuff in this area. This is kind of a novel approach, and we'll see what's going to happen. I mean, generally up until now, celebrities, sports stars have been relying on states' rights, the right to publicity. And it's kind of broad. It can cover anything, any sounds or something relating to an actor or any kind of celebrity, and which basically conjures up the celebrity. The downsides is each state has its own right to publicity. Some are stronger than others. I believe Tennessee just passed something recently. But you have the limitations of you're basically limited to state court. Enforcement in different states can be kind of, I don't know about hazardous, but as I mentioned, different levels. And there's a number of advantages in being in federal court. And therefore, this is kind of a unique approach.
Yeah, so the uniformity, it sounds like, of the federal trademark system allows these actors to have the same kind of protection everywhere as opposed to relying on sort of a patchwork in different states.
Correct. You're going to have consistent rights. There's also advantages of incontestability. There's also advantages of statutory damages. So there's a number of different advantages using the federal system and the USPTO in getting those rights.
Yeah.
You raised an interesting issue about commerce, et cetera. And
Yeah.
with respect to state law and the right publicity, you don't have any requirement that it's associated or the mark is associated with a particular good or a particular service. And in federal trademark law, you have to have what they call use in commerce. And so Matthew McConaughey, he's got trademark registrations for his sound, likeness, actions, motion, sensory type of movements, And I mean, even the all right, it's like it has to be like a lower pitch and then a higher pitch. So it's like, all right, not any like that. But also, he's limited to the goods and services. I forget whether, or there might be one of each with each mark. And so the question is, well,
Hmm.
what if someone's not using it in respect to those kinds of goods and services?
Yeah.
And what if he's not using it? And can he maintain the registration?
Interesting. Yeah, those are some interesting questions. I think it really sort of begs the question of what are some of the dangers of allowing these sensory marks to get so popularized, right? At Stein, we deal with mostly word marks, sometimes some style marks. These are almost a whole different ball game of trademarks. Are there risks to these kinds of marks?
Well, I guess the enforcement, like, I mean, the big question is going to be how close do you have to be? Is Matthew McConaughey going to go after every single person who says, all right? I mean, what if you go, all right? You know, so how close do you have to be in that respect? Or what if you're using it in a totally different context? How broad of coverage? So the risks are how much protection does he get? Does he get anyone who's got kind of his hair sitting in front of a fireplace or sitting on a porch? Uh, you know, as far as word marks and logos, there's a lot of established case law in relation to this. This is kind of brand new. So one of the things that people, you know, are wondering how valid, just because the USPTO allows them, how valid are these marks?
Hmm. Interesting. And sort of another aspect to their validity is when you trademark the way that a phrase in particular is said. What about when the phrase is extremely common? Like, all right. Seems like a pretty common usage phrase. Trademarking the specific way it's said, does it create, is it, do you think, overly limiting, overly broad?
I mean, because if you look at the actual trademark registration, I believe it says something like the first syllable being lower and the second being higher. But it doesn't limit it to it has to sound like Matthew McConaughey. And it kind of reminds me of it's in the copyright field where Taylor Swift said something like the players are going to play. And I forget, I don't listen to a lot of Taylor Swift music, but and then someone I think had an older song that used similar words, and that's
Mm,
word marks and that's copyright. But even in the trademark realm, you know, how much of a likeness? What if you get somebody who kind of looks like him? I mean, there's sound marks. I mean, with the NBC mark, da da da, or the Netflix mark, the sound mark. Uh, I don't know. Yeah, but for some reason, I'd think I'd kind of know whether, you know, I don't even have to be watching the TV. I know that's NBC, right? Or I know that's Netflix, or I know that's Apple. How close? I mean, people are going to try to push the envelope, right? Oh, Matthew McConaughey, and you kind of want that. Oh, is he endorsing it? Or, oh, people recognize that. Uh, so AI, this is just another area. It's a very innovative, you know, kudos to the attorneys for Matthew and I think Taylor, and it's going to be more and more, and we'll probably get into that. It's kind of an exciting time. And what's going to play out is what's going to happen in the courts. I mean, there's so many issues with a lot of AI and patents, AI and copyrights, inventorship issues, even novelty issues, authorship. And so we'll have to see. But at least he has the registrations. He's got something to rely on. He's got some, uh, you know, some piece of paper, some rights to make people pause. It's also going to make, to some extent, AI creators think more about, oh, I have to be aware of this kind of thing, and maybe I'm not going to get quite as close. I mean, there's no
mm,
such thing, Sahil, as you probably know, of absolute protection in anything, right? You can have
Yeah.
a life insurance policy and they say, oh, well, you smoked and therefore you did this, or somebody could sue you at any time, and a court can always say something or the other. So it's just trying to add an additional layer of protections, especially since you don't have to hire an actor look like Matthew McConaughey, right? You can,
Yeah.
uh,
Just have
or,
AI do
or
it.
yeah, or what happens if you have me or you just say, all right, all right, all right,
Yeah.
is that an infringement? Because according to the trademark registration, it doesn't even have to say, as I mentioned, Matthew McConaughey's voice.
It just has to follow the pitch indicators. Yeah. I think
Whichever that
another
means. Yeah.
yeah, I think another interesting sort of question that this poses is if Matthew McConaughey only pursues litigation or only seeks to enforce the trademark against AI generated versions of himself saying it, does that almost one thing we've learned here is that enforcement dictates the bounds of the trademark, right? If you don't enforce a trademark ever, it's the mark almost is as good as not existing. So if he only enforces it against AI versions of himself and not against people like you or me, does that almost redefine the mark to only be against AI versions of himself?
I don't see why he would limit it to just AI and
Hmm.
deepfakes. Why would he do that? I mean, he's got the trademark rights. It doesn't say. I mean, this is kind of what prompted him is AI, but it, if you hire an actor that looks exactly like him, and it's not AI, I would think he would have the same rights. But
Hmm.
as we've discussed, you also have the issue of if he's not using it with any goods and services, is he going to be able to be enforceable in the first place? How is he going to renew it? And so is he going to have to take some actions just to keep the mark alive according to trademark law, which you don't have to do anything relating to that with respect to state law, and which you get automatically without
Hmm.
any type of application or registration.
Oh, that makes sense. So another question of um, is related to when obviously Matthew McConaughey coined the mark, and it's obviously his, but could someone take the mark of a like someone else's catchphrase, say it in their own way, and then trademark their own version of that phrase if they're using it in commerce? Is that if we're allowing common phrases to be trademarked as long as they're in specific said in specific ways, it sort of opens the floodgates to a large variety of different trademarks, doesn't it?
Yeah, I mean, I think a large extent is how unique they are.
Mm-hmm.
And so if you just have, um, all right, all right, all right, the words, I mean, he doesn't have the mark as far as I know for just the words. And so if you put
Yeah,
that on a t-shirt, for instance, I'm not sure. I didn't look at it
I
super
think he might have a
carefully.
separate word mark for the words all right, all right, all
Okay, in
right.
that case, yes. But if he's getting, if someone's getting these sensory marks and you use it in a different context, and I don't know for all right, all right, all right, I forget what exactly the goods and the services are, but if you're using it for something totally different, let's say, I mean, I don't know if it'd be applicable, but let's say you've got vacuum cleaners and you say, yeah, that's all right, all right, all right. Is someone, are they infringing the mark? And well, I guess it depends on how you say it. But if you put it on the vacuum cleaner itself, or put it on e-commerce, uh, a lot of interesting things. But I credit, as I mentioned, the attorney who's like, let's get this started. Let's get something. Something is better than nothing. Clearly, Matthew can afford the legal fees, and uh, why not try it and seek enforcement?
Yeah, and it opens a whole new area, I think, to like trademarks that we might not have otherwise
New
explored.
world. There's always, I'm working on something now with, before a client had retail stores and now they're just selling on e-commerce, and there's a provision about technological innovations. And so we can amend the goods or services relating to that. So things are always changing. That's what I love about
Yeah,
IP. It's not just patents, it's copyrights, trademarks, trade secrets. Things are always changing. Uh, it's interesting, but I think
Yeah.
we're running out of time. Fantastic questions. Great interview. Thank you for being on the podcast. And to my audience, oh, any parting words?
Thank you for having me. And yeah, I appreciate your answers. It was really insightful to learn a little bit more about what is this whole new area of trademarks.
To my audience, until next time, and the next time is going to be me interviewing Sahil on the topic of gaming, I believe.
Yep.
All right, stay tuned. Take care. Bye.